Heard, and I claim Heidi with great legitimacy as my daughter, and my son-in-law, Michael, both of which, as you know, are difficult people to follow. But I will take the liberty to say that old age will be my excuse or my justification, or your excuse or your justification for any mistakes I make, which shall probably be many. We've handed out the International Declaration of Indigenous Rights. Everybody got a copy of that? I will not touch that today, but I would like for you to give it a read overnight if other pressing duties and intellectual activities do not forbid that, because the presentation and the discussion is really aimed at the International Declaration of Indigenous Rights, which took us, and I'm going to include myself in that, because Jim Coulter, head of Indian Rights and Indian law in the United States, he and I were over several beers in the UN in the Palace of Nations in Switzerland 25 years ago, sat and did lists of things that we thought ought to be in an International Declaration of Indigenous Rights. And so I take some pride in the passage of that 24 years later by the General Assembly of the United Nations. So I've followed this all the way through, from the beginning of it, with a tab and a piece of paper in a hotel in Geneva. And that is really, in a sense, the apex of the present, shall I say, policy, because it's a non-binding declaration, but nevertheless, it has been very powerful. I've been involved recently in 3 court cases, 2 at the tribal reserve using tribal courts, and 1 in the Queen's Court bench of Manitoba in Canada. So it is now having its influence, and just as a matter of, before we get started, was passed by 143, I believe, nations in the General Assembly, 4 against, which was the United States, Australia, New Zealand, and Canada, all of which now have adopted the International Declaration, and there are 11 extensions. And I ask this question, and then we'll sort of proceed. There is no other, ask yourself, there is no other declaration in the whole set of international declarations and covenants by the United Nations which specifically addresses a class of people. There are children's rights, there are women's rights, etc., etc. There's non-discrimination declarations, and if I get a chance, I'll get duplicated for you the page after page of motions by declarations of the General Assembly of the UN on local, etc., regional and international declarations, but none address a specific class of persons. And I think that's quite unusual. So I want to ask you the question. You need not necessarily respond, although I'd appreciate it. How would you define, or what kind of characteristics would you speak to if you were defining indigenous peoples? You may even ask yourself the question, are you yourself a descendant of an indigenous peoples? are often described, as Australia and Canada do, Aboriginal peoples or Aborigines. Are you yourself from a class of persons who would be classified or described as or thought of or within a nation state defined as Indigenous? Let me just ask the question. How would you define Indigenous peoples? First of all, let me just say, I just want to thank Sergei for either inviting me, and I think it happened to be a kind of a conspiracy to attend and participate in your affairs. And so thanks, Sergei, and Heidi and Michael. So define for me, or how would you describe, or if you are a descendant of an Indigenous person or Indigenous groups or Indigenous peoples, how would you describe yourself? How would you describe your background? 1 million to 350 million. The International Association of Archaeologists go as high as 700 million. Again, I think the question is, we're not quite sure what the definition of Aboriginal or Indigenous is. The United Nations, I'd rather read it to you, have some of the things, the United Nations Working Group, and I'll come to the working group if you are not aware of the Indigenous developments in the United Nations. But one of them is sort of what we call historicity, in the sense of long time at a given territory. Secondly is they have different or unique or separate kinds of languages, cultures from what might be called the general culture of the dominant state. So that you can, in a sense, define it culturally, different language, different cultures, etc. But there are minority groups have different cultures, etc., and maybe speak different languages within the dominant state. And so we get down to sort of two kinds of issues which seem to sort of, what shall I say, be prominent, and for which, quote, quote, Indigenous peoples are concerned about. One is territory, land, and secondly is the whole question of, and that's a difficult term, self-determination. Most of the minority groups we see in the United States, be the Afro-Americans, or if they're are not concerned with territory or even self-determination. They'd be more concerned about sort of somehow keeping a cultural component within the dominant nation. And this has been a great criticism about sort of, what shall I say, defining and in a sense keeping groups, if you want to call them, as a sort of a specialty within the population of a nation state. Why aren't Afro-Americans in the United States? Or why not, for example, the Inuits, for example, within Canada, or within Russia, or wherever they may be, or within Alaska? Are they something that integrates within the dominant society, both politically, economically, socially, or they're involved economically within the economic system, they're involved in the political system, they may be separate, but they vote, they carry on various other things within the dominant political institutions, and yet do not think of themselves necessarily as separate from, distinct from, and therefore deserving of special protection, special legislation, or special declarations. And may I ask the next question, just name for me some of those persons or groups who are considered themselves and so recognized as Indigenous peoples.
US Indians, for example.
the whole issue of Indigenous rights, identification, their authority, their self-determination, their rights to territory is now being moved into the international field and thus into international law. And I'm not suggesting that the International Declaration is law or a covenant yet. But when you have 143 nations approving it, 4 nations objecting who now has approved it, all you have in a strange sort of way are 11 abstentions. And so the indigenous person, the indigenous groups no longer rely totally on protection within the dominant nation states, be the Indians in Canada or the US or in the whole hemisphere, north and south, but the western hemisphere. And I'm going to jump just a little bit here because I'll come back to it later. But one of the most interesting political and cultural and recognition developments that are going on are the Inuits. And you may or may not know about having been involved in it. I might say parenthetically, I used to be an academic. I'm no longer an academic. I'm a full-time lawyer for Indigenous peoples. And one of the things that I have been involved in, not to the extent other people, is the development of the Circumpolar Conference, which are Inuits, Canada, Alaska, Russia, the Scandinavian countries. And those are all coming together now and called the Circumpolar Conference. And it's developing political institutions, political congresses, and interesting enough also is that while they cannot speak in full sentences, there is much in the Circumpolar Inuit language of which they can understand each other. And that's rather amazing in itself. So the headquarters of this is, one is Ottawa, Canada, and that grew out in part because of the new province in Canada, which is Nunavut, which is north in the Baffin Island area. That is now a province within the other provinces of Canada. And that came in after the patriation of the Constitution of Canada, signed in 19, I'll think of it in a minute, and signed by the Queen. So Canada has a new constitution within the last 25, 30 years. And those of us who worked on the patriation of the Constitution of Canada were working in the areas of defining who, not necessarily defining, but putting in the Constitution of Canada the protection of Indigenous rights. And that was one heck of a fight. And at that time I was on both sides of the fence, having served as an advisor to Prime Minister Trudeau because of my own background in the United States, where the American Indian movement has been much stronger in one sense than it has been in Canada. And now the Constitution of Canada, Section 25, which is the Charter of Rights, specifically recognizes there are 3 Aboriginal peoples in Canada: the Inuit, the Indian, and the Métis. The Métis being the mixed races between the Aboriginal peoples and others, heavily French. They had no status in Canada. The Indians had status under the old British North America Act, Section 9124, in which it says Indians and lands reserved for Indians, Section 24. So that was sort of a federal authority, but now then, they are also included within the Charter of Rights, Section 25, and they have their own protection in Section 35. The point I simply want to make is that in order to even get those, we had a heck of a fight, not only in the courts in Canada, but also the courts in England. And we carried on a dual process, vis-a-vis lobbying the Parliament, and as you know, Parliament has no offices like the United States Congress, etc., you had to catch them in the hallways, etc., because parliamentarians, as I say, do not have private offices in the British government. So we caught them in the hallways and the cafeterias and various other places, parliamentarians, to, in a sense, object to, even then, what passed, but even then, Indigenous peoples did not approve of Section 25. One, they didn't want to be on the Charter, and secondly, 35 was not inclusive enough that they thought would protect them. So we went through the courts of Canada, and the Supreme Court of Canada, and on the basis of the Canada Act, which later became the Constitution of 1982. And then we moved to England because the Constitution of Canada was at that time only the British North America Act. And that's rather interesting as a parenthetic here, that India, the nations of the Commonwealth, had their constitution, including Australia, including New Zealand, etc., had their constitutions long before Canada, and Canada never got its own constitution until 1982. Now the British North America is still a part of the constitutional framework of Canada. The point again I'm making is the only reference to Indigenous peoples in Canada was only Indians under Section 9124. The Supreme Court of Canada said, however, that Section 9124, which speaks of Indians, also applies to the Inuits. So the Inuits were brought in under Section 9124. But the Métis, the mixed people, were not brought in as Aboriginal peoples of Canada until the Constitution. And in Section 35, it defines as the Aboriginal peoples of Canada include Indians, Inuit, and Métis. But from the Quebec people, from the French viewpoint, they did not want to be considered Aboriginal. And so when the definition of a term came up, they wanted to be, that Quebec has and had at that point its own ambassador in Great Britain. That's one of the arrangements that Trudeau did, is that Quebec could have its own foreign service and would not necessarily have to go through the Foreign Office of the Government of Canada. There was cooperation. The interesting thing is, however, is that we spend a lot of time lobbying the Quebec Embassy in London to support the disapproval of Section 25 and Section 35. We could not, we had support from Scandinavian governments on whether 25 under the Charter and 35 within the section would meet the Indigenous peoples of Canada. But I'm just pointing out here that while they had the sympathy of Indigenous peoples being more specifically, what shall I say, identified and protected, in many ways it was the French who wanted less protection under Canada. They wanted to be more independent. Is that an answer, Michael? It was really a political movement as to whether or not, and when Trudeau began to think about how to unify or bring Quebec more into the system, was that he would not necessarily bring them under the Aboriginal issues, but he would bring them under a general special thing. And in fact, that's what's happened in the Patriation of the Constitution. Quebec has a very special status outside of, if I can put it that way, outside of what would be any other province in Canada, because concessions were made in the Patriation Act, in the Canada Act, which repatriated the Constitution. But it's rather interesting that since Quebec had an embassy in London, that we lobbied the Quebec people through their embassy to help the Indigenous people, even though Quebec is a province of Canada. Any other?
I just want to clarify if everybody knows that the word Inuit means in Russian.
I'm sorry.
In Russian we have the word for Inuits.
Because you'll have Newfoundland and everything else east of that, including Quebec and Ontario. But sitting right in the middle of Canada, called the Key Province, is Manitoba. And Louis Riel, who led many of the Western Indian movements, developed basically the Métis kind of middle class. We don't use men. We don't have no constitutional provision for mixed in the United States. But the Métis, the province of Manitoba is really sort of the center of the Métis, and in many ways developed and was the first governing body within the province, what is now the province of Manitoba. And Louis Riel, the famous sort of Métis leader, shall I say, was the main leader. The question then is, since they become constitutional recognition, the logical place for them to claim land is in the province of Manitoba. And is that happening? Not yet. They are identified again as groups, particularly heavily in partially Winnipeg, the large city, but also in the suburbs. And the point I'm making is there are tremendous movements now, even after 1982, to identify lands which were originally made by the mixed breed, the Métis. And there is some distinction going on now in Manitoba specifically, some in Saskatchewan, because Louis Riel was murdered in Saskatchewan, not in Manitoba. And so there is movement in Saskatchewan, the next province west, to identify lands which are racially Métis, in other words, territory for the Métis. And the Saskatchewan government has been sympathetic to that, but to my knowledge has not gone so far as to say, here are lands that now belong to, or in which the Métis has jurisdiction over. Now there's a big problem here, if I may just parenthetically. When Canada became a nation in 1867, the provinces, the original provinces, Ontario, Quebec, New Brunswick, Nova Scotia, Martha's Vineyard, etc., those were the original founders of the Canadian Constitution of 1867. And therefore, in the Constitution of 1867, they maintained, because of they were the original part of the Dominion of Canada, and so they maintained, they owned all the land in the province. There was no federal lands in the province. Well then, when Manitoba then came through, i.e. the negotiation of treaties, the question, because all those were Hudson Bay lands, which later then became federal lands, and so at least Manitoba, Saskatchewan, and Alberta, because the British Columbia is a different issue, you can view the map. So those three provinces in particular said, look, here we are, but these are federal lands, and we want to be like the 5 original provinces. So in 1930 and 1932, the federal government by the British, which is an amendment to the B&A Act, passed the Natural Resources Transfer Act, transferring all the lands under federal jurisdiction to the provinces. In Canada, there are no lands belonging to the federal government except national parks. In the United States, that's just the opposite in many ways. Where I am from, Laramie, Wyoming, and all the western end are tremendous federal lands, millions of acres. In fact, the state of Wyoming itself has more federal lands than it has under its own jurisdiction as state government, including the national parks as Yellowstone. So what I'm suggesting is that once they move the national lands from the federal government, who has jurisdiction under 9124 over Indians and lands reserved for Indians, they transferred all those Hudson Bay lands to the province. So the question now is, and the problem now is, while 91 is now still the constitutional authority, along with Section 25 and Section 35 of the new Constitution, or the addition, they have to deal with the provinces. So the federal government, by an act of the legislature, of the parliament, cannot by law, unless it amends 9124 and possibly Section 35, can in fact have much to do with saying, okay, we've recognized a group of people as Aboriginal peoples under the Constitution, but we have no authority at the federal level to give them territory. Do you understand what I'm saying? So so the Métis are not so much wrestling with the federal government, but they're wrestling with the provinces. And that is, in many ways, the difficult problem of the Métis, because Manitoba does not want to give up land to the Métis, because they already have 63 reservations, the Indian reservations in the province, and to then carve up the province even more and saying this is Métis land is just not a go. Saskatchewan, in many ways, at the moment, is much more sympathetic to that notion, but the government in Regina, the provincial capital, has essentially sort of said no, even though the political party, the NDP, New Democratic Party, heavily in Saskatchewan, is heavily made up by voting of the Métis. Do you follow me? I mean, we got a legislature in Saskatchewan who over the years, still to today, who are made up heavily of Métis background. But even they, with Métis background, are hesitant to sort of say, this is your territory, so this is yours, or this was yours, and now we will reclaim it for you. It's not happening at a very big level. However, I just want to say that the political organization of the Métis nationally, and again particularly in Manitoba and Saskatchewan, less in Alberta, but is a very powerful political organization with really very dynamic leaders. So they press very hard against the state legislature, both in Winnipeg and in Regina, if not for territorial identification and jurisdiction, are nevertheless pressing very hard for, shall I say, equal rights among the 60 reservations in Manitoba, and I can't remember exactly how many is in Saskatchewan, but it must be around 57. And that's a big political struggle. Does that sort of identify the tussle that's going on? And when the NDP government is, and the New Democratic Party, which is a very liberal political party, when they're in Manitoba, Saskatchewan, those are the two big holds for the New Democratic Party. Again, there's a great sympathy and there's a great sort of movement towards medical care and cultural identification and cultural centers and cultural language institutes. But they've never quite gone and say, hey, the northern part of Lake Winnipeg, for example, will be Métis. Now, when you come to the cities like Winnipeg or Regina or Saskatoon in Saskatchewan, the cities are much more, how shall I, sympathetic to special services for the Métis. And that's a kind of a difficult one because the Métis occupy a certain north end portion of Winnipeg, while incoming Indians from the reservation, because Winnipeg says we are the greatest reservation in Manitoba, is a city because they're coming in for employment purposes, etc. And so again, the same pull is sort of there, trying to adopt or trying to give credence to certain special privileges to the Métis, also recognizing, however, that Indians coming off reservation into the jurisdiction must be treated much more like the residents of Winnipeg. And the provincial legislature is very interesting to watch on that. What the outcome is, I have no idea at this moment. And as I indicated a while ago, I used to be an academic, but I'm full-time in the last 40 years as a lawyer for Indigenous peoples. In Canada heavily, in the United States, Northern heavily, and then representing others that will come to us within the UN, as for example, the Maoris of New Zealand, Aboriginals of Australia, etc. Does that sort of handle this? And that's one of the very frustrating things. I've never worked for the Métis. One, because there's no sort of political body that you can relate to. All of my work has been and still is with the Indians, because they do have territory, they do have jurisdiction, they do have, in an interesting way, what shall I say, and in Canada, the Indians are known as First Nations. Not the Métis, even though they're identified as special under the Constitution. They're not considered to have any national, I'm talking about Indigenous national status. But the reservation Indians with territories are all called the First Nations of Canada, going back to sort of the regionality of that. Just as parenthetically though, you have to, if you not know the political history of Canada, most all the prairie provinces at one time was owned by the Hudson Bay Company, which was a special charter from London. And when Hudson Bay gave up the lands, they went back under the Natural Resources Transfer Act. They were included back now to be lands of the province and the jurisdiction. And that includes both subsurface rights as well as top. So the provinces have full authority now over their land, equal to the original 5 provinces, because they had to make that jurisdiction. And the Indigenous people got caught up in that, particularly the Métis.
Well, I was going to ask if you would say a word about, you probably are getting to this, but I was wondering about the difference between Indians in Canada thinking of themselves as First Nations and the way in which, for example, the American government came to think of its Indian peoples. That is, there's a different history between Canada and America in the treatment of their Indigenous peoples. Different again than Australia, different than New Zealand, and they lay claim to different status in these different countries. And some lay claim to more sovereignty or nationhood than do others. I know you're getting to that, but since you were stressing them as First Nations, I thought I'd raise that.
No, I think that we might, but since we're off on that track, I'm down to the English perspective.
Okay.
Don't mind jumping around. Let me just go back to the English position. Let me just say, first of all, the Spanish position. When Columbus landed in 1492, October the 12th, there soon became a tremendous squabble who owned the new territory. And there was a hell of a fight between Spain and Portugal in part, and the person who jumped into it was Pope VI. And under the notion, and under the theory that the Pope was sovereign, he then could declare that whose territory it was, and at least in Mexico and the countries hooking up to the larger part of South America, Guatemala and all of those, the Pope claimed it for under the jurisdiction of the Church. And it was 3 years later, 1495, that Pope VI, who in Catholic history has been sort of deemed as one of the questionable, worst, not so straightforward Pope, issued the papal bull of donation. And the question was, well, how do you claim, for example, sovereignty over, or claim that the lands belong to Spain? And the interesting thing about that, in the papal donation of roughly 1490 to about 1493, only about 2 or 3 years later, the donation came down. And this is what the donation said, provided for. One is, there was somebody moving around, I guess called people, but they had no language. They were not Christian. They had no art. They had no culture. They had no government. Therefore, there were no people. And therefore, you could take it by discovery. That was the old doctrine of Hugo Grotius. Discovery only meant land. And within 3 years of that claim, and the figures are not always, don't agree with, but the American Anthropologists Association, I think even the International, they don't agree, they agree on the little figure, but they don't. 13 million people, 13 million Aborigines in Mexico alone, it is now Mexico, were slaughtered because they weren't people. The American Archaeological Association moves that up to over 15 million. It happened 3 years after Columbus, 3 to 4 years after. So the question, then you could say, as it did say, then the land becomes ours, under our jurisdiction, because since there were no people there, we discovered it, and there we did it by basically discovery. That got in the way of them a little bit, and the Pope had to change it a little bit to say, well, there was somebody there called people, so we did it not only by discovery, but we did it by conquest. That is basically the Spanish position. Now, I mention that because the notion of no people there, or the notion of back people, backward people, is still in many ways not talked about in the indigenous world, nor do we as sort of lawyers, etc., nor do policymakers really want to go there. But the idea, being backward, does not necessarily how shall I preclude annihilation of them. So when the English came along in 1763, 13 years before the American Declaration, the English monarch proposed the Royal Proclamation. And the Royal Proclamation of 1763 said, basically in the northern part, that is U.S., Canada, because they were much more involved there, while Spain was much more involved in Mexico, etc. The English said, there are people. The Royal Proclamation recognized that. Secondly, they had land. Thirdly, they had title to land. This is the very interesting thing. They had title to land. And any settlements coming to Canada or to the United States, because the Royal Proclamation, there's huge kerfuffles over this, but the latest doctoral thesis about 18 years ago from the University of Toronto, it's 900 pages long as a PhD thesis. Anybody here wrote 900 pages as a PhD thesis? And he pretty well documented where did it go. I mean, what was the territory of which the Royal Proclamation talked about? And it's pretty clear from his investigation, from his research, because his research was on the Royal Proclamation, and he came to the conclusion that the British monarch, not knowing everything about the east coast of what is now Canada, U.S., went all the way from Labrador to Grenada. And that's still in dispute. Secondly, it only went inland to the Appalachian Mountains. In other words, in Canada, it went in basically only to Saguche, Quebec, which is right out on the end of the St. Lawrence. Now, the doctoral dissertation at Toronto says no. What it really meant, it extends to those territories we know of, but it also extends as far of lands that we don't know about. Now, in that proclamation, there was one very interesting thing in this sense, namely, settlers could not take land in Canada or the U.S. prior to the American Declaration unless the land was, by the Indians, by the inhabitants, ceded to the Crown. In other words, you just couldn't come and sit on it and say, well, I have a land grant here by some lord, or there's nobody else here, so I'll just settle on it. So the Royal Proclamation put an end to that and protected the Indigenous peoples from sort of simply being surrendered, being acceptable by or pressured by simply people who came over and landed. There's one of the big arguments in Jamestown, which is very seldom spoken about, and also Plymouth, that, hey, the Royal Proclamation extends and you just can't come across and land. And the British raised that issue, not the people in the U.S. at the time, but other than it. But it wasn't raised later under the Confederation, Articles of Confederation. It was actually raised by the monarch. You don't have a right to settle there, because that land has not been ceded to the Crown. So there was a kind of recognition, title, self-government, they had languages, they had art, they had government, etc., which was the thing very denied by the Spanish. And furthermore, you cannot settle on those lands until ceded by the Crown, and until those lands are ceded by the Crown, ceded to the Crown, however, has a trustee relationship with you. And that concept, the notion of trusteeship over Indigenous people, is what I will talk about, because it's still a part of the United Nations Charter as it was a part of the League. So the English took a different approach, if I may say so now, a different approach to basically Indigenous peoples in Canada and in the United States. Now, in 13 years later, in the Royal Proclamation and the development of the Articles of Confederation, etc., the U.S. took control of treaty making with the Indigenous peoples, which ended, however, in 1871, I believe. There are no longer treaties being made. And the U.S. also accepted the notion, not well defined, of being a trustee for the Indigenous people. That is, their welfare was in fact a responsibility of the U.S. government. And there's some early decisions along to that, but because of John Marshall's decision in the Georgia case, I can't even remember a moment, when Marshall declared that they were dependent nations. Not absolute in terms of foreign affairs, etc., but they were nations dependent upon. and this is a trustee relationship. And the US has done a better job in that sense of recognizing that trust relationship than Canada in a sense, because the US has taken that relationship as a legal kind of mandate, while Canada has accepted the notion it's only a political mandate. In other words, it was a political move on behalf of Canada after it was organized in 1867 as a separate nation, or as a nation under the British. Now, what that meant to say then is, if you look at the eastern US, in which there were Indians, and they were pushed back over the Appalachians and the Alleghenies, while in Canada, and then it later became that most of the control over Indians, particularly as they moved west of the Mississippi, were under the control of the army. While in Canada, as they went west, Manitoba, etc., and then became part, and then the Métis arose because of the interbreeding, those were under the supervision of the Royal, Canadian Mounties. So in the pattern of the US, the same sort of thing had its underpinnings though. They were backward people, even though they had certain ingredients of which the US recognized: land, territory, and government. But the question became, how do you handle those, particularly as they were pushed west? But then the question became as what happens in the development of the West, and that same problem developed in Canada. And it came especially developed after the Hudson Bay Company ceded all of its land back to the provinces. So how did the provinces and the federal government reacted up until 1934, when all those lands were transferred to the province itself, and reservations. So the whole reservation idea came along. In the US, lands which they had been sitting on, Indians, whether it be Cherokee, whether it be Potawatomi in the east, or as they moved west and met up with the Muskogees, etc., Comanches, Rappahoes, etc. So there was a different kind of handling of Indigenous peoples in the north, vis-a-vis the Royal Proclamation of 1763, and then a difference of how the US and Canada handled those, because the US then moved the army in very early to control them, to move them, etc., and put down versus rebellions, while in Canada it was taken as a kind of a police role in terms of the Royal Canadian Police. Does that sort of get to it? And then it became, and I should move further, but then there is an element of the Spanish position in this, because they were considered in some ways, in most ways for a long time, backward. Secondly, what to do with them, i.e. do you keep moving them west? And then the whole question of the policies that developed, i.e. separation, move them, or secondly, integration, get them within the system. And both of them were, in a sense, moved at the same time. While the army was moving them to put them on reservations through a treaty process, there was, through the army, the whole development of school systems, particularly churches, the Catholic Church being the most, what shall I say, aggressive about educating them into Christianity, and in many ways into English, and had to learn the arts, not Indian art, but they were learning the arts, and also the question of government in some sense. And I have a number of friends in Canada, of which I have worked with over the years, who were products of the educational system to make them less backward, to make them civilized, and to bring them into, particularly the value system, heavily Christian. And one of my very interesting colleagues and mentor for a good many years in the Canadian situation was the fact that when he was 3, he was yanked out of his home, as well as his other brothers, sent off 30 miles away to a Catholic parochial school where he had to forget his own language, forget his own traditions, i.e. the Indian religious ceremonies, and at the age of 3, he kept wetting the bed. And so they got him up, and the nuns and the priests got him up at night and tied him to the bedpost. And if he's going to pee, he pees on the floor, but not in bed. And then he was beaten for peeing on the floor. Now this is pretty psychological, it would seem to me, and the psychologists have written a great deal about this, although I don't have that great a respect for the psychologists relative to Indigenous people. Sorry, scratch that. But the point I'm making is there was an element in the English even who recognized the rights to land, but as the settlers moved west, those lands had to be made open for immigration, and certainly in Canada. And by the way, that great movement was in part done by the massive migration to Canada by Ukrainians. Go 30 miles west of Edmonton, Alberta, on the Yellowhead, and you will see huge monuments, not monuments, but reproduction of Ukrainian farms. And it covers a whole 640 acres, a section of land. And to get that land for Ukrainians to come west, others came, but the Ukrainians are heavy in Manitoba, Saskatchewan, and Alberta, because this is some of the wealthiest lands and most beneficial agricultural lands in North America. And the Ukrainian farmers, still to this day, have the Eastern Church, but there's this huge, huge development, 640 acres, of a typical Ukrainian farm, etc. Now what I'm saying is about that, in order to accommodate the Ukrainians, the Indian land was then had to be sold or basically taken. And a reservation just on the west side of Edmonton, which is now almost within the city of Edmonton, which is Cree, because the Crees much are across the northern part of Canada, and then the Ojibways, and then the Algonquins, and then you're in the U.S. Those lands outside of Edmonton were taken unilaterally and by force by the government of Alberta, and the Indians were pushed further west. And that has now become, and has been since, probably late 1800s to the First World War, that has now become basically a whole community of Ukrainian farmers. I mention that only because the Ukrainians, your own people, those of you who are of this nation, have had a strong influence in agricultural lands in Alberta and in Saskatchewan in particular, less so in Manitoba, but they're still there. And in order to make those lands available, the Indian population were moved to different reservations. That's a Beaver Lake, that's a Saddle Lake, 120 miles north of Edmonton. So in a sense, not because of Ukrainians, that there was a sense that if you didn't use the land, then you could be moved out of it. And use being defined basically as agriculture. Well, the Indians were not agricultural, and much more the roaming type. So in a sense, you could move them. That's been a big sore spot within the Canadian Aboriginal people. Under the new Constitution of Canada, they're Aboriginal peoples of Canada. The U.S. has not used that term. Now coming back to the south side, whereas population developed on the east coast, and the Cherokees and various others were moved west to Oklahoma in particular, then the whole notion, the whole development of the trusteeship, if I can use that term, to civilize them, to bring them into Christianity, because after all, their traditional religions were false gods. And to do that, the rise of the parochial schools. Now, interesting enough, within 4 or 5 years ago, just jumping again in a rather disorganized way here, Canada has appropriated $850 million to the Indigenous peoples who were then gone through the parochial system. And those monies are going back to the families, and I have helped fill out the application to many of them, while the U.S. has made no effort as a government to compensate anyone who was forced to go through parochial schools. We still have parochial schools in the U.S. Canada has still parochial schools, in which the school system of a community, Casco, Montana, refuses to do any work for the reservation there, and so the school board. So the church has moved in again in recent years to educate children from the reserve, even though they have their own school. But so there was an element of, what shall I say, bringing the backward nation into the culture, the truth, etc., both in Canada, but heavily in the U.S. by the Army, because they could gather them up, put them on a reservation, and in Canada it was done by the RCMP, the Royal Canadian Mounted Police. I don't know whether that answers your question.
Well, so what I'm wondering is, it sounds like it overstates it to say a compliment, but if you have the view that when you arrive, people are people, they have territory, they have culture, they have governing institutions, you pay them the compliment, as it were, of at least engaging in the fiction of entering into treaties with them, right? You take them to be autonomous, self-governing entities, and so the right answer is to negotiate and to construct contracts or treaties. And did the Spanish not use treaties as a tool of negotiation? They didn't take them to be worthy partners in contracting.
Well, since they had no government, so to speak,
there wasn't anybody
nothing
to negotiate treaties with.
Secondly, they were not really people, because they weren't Christians, they didn't speak Spanish, etc., etc. So, and that's the way you got to the question, and no art, etc., no language. That's how you got to the question from the Spanish viewpoint, and the donation, the papal donation, gave the prescription for this. If you didn't speak English, if you found no art, if there was no government, etc., then you had the perfect right to simply kill them, because they were not people. Now that's not true of the U.S. in this sense, because under the Royal Proclamation, treaties were entered into. So there was a recognition that there was a government, there was culture, there was, shall I say, art, and that is, there was a community of total, what shall I say, activity. And it was then that the Army became involved in negotiating treaties. In Canada, the Canadian government appointed, well, it's supposed to be done by the Queen, because Canada was not yet then fully, shall I, a self-governing nation, and partly because of the lands belonging to the store. They sent a negotiator, Gouverneur Morris, did most of all the prairies. That is Manitoba, Saskatchewan, Alberta. Now the Treaty of 1850, which is a part of Ontario, that was negotiated by a representative from the Queen's office, that is from London. Now Quebec, most of the treaties in Quebec dealing with Indians are French treaties going back to 1600. And Canada's not always recognized in early treaties in Quebec. And those are being regenerated now and recognized by the federal government of Canada as legitimate treaties, and therefore are being treated as treaties, and whatever those conditions were. So even as they came west and met, quote, the Sioux, the Dakotas, Lakotas, Nakotas, which is Minnesota clear to the Rocky Mountains, that whole area was negotiated by the Army, and the Dakotas, the Lakotas, and Nakotas are all part of the great Sioux Nation. That is one of the great treaties, and it covers most all the states, if you have a picture of it, for example, Montana, Minnesota, North and South Dakota, clear down almost to where I live in Wyoming, and clear up by the Idaho border. That's the great Sioux Nation. And that's a great treaty, and it's a tough treaty.
Did the treaties do more than convey sovereignty? Did they actually convey land title?
Yes, they did. They recognized title to land. It's not in the private sense as we know, but they did have tribal. That was the notion of the reservation, that they had title to land.
So the English perspective recognized not just sovereignty, but
No,
Indians'
sovereignty.
own land.
Recognize local sovereignty?
It recognized not only sovereignty,
Only sovereignty.
but also that the Indians owned the land.
Yes, had title to land. And in a sense what this did is, because again, this is the sort of, well, the Alaska land claims, I'll come to that a little bit later, because Alaska, from my viewpoint, as a part of not only the Indian, but the Inuit in Alaska, particularly the Indian, came under the Alaska land claims, and I'll discuss that differently, because the Alaska land claims in Alaska for Indians is, from my viewpoint, and I think the documentation that has been basically a total disaster. There are some reservations in Canada who are doing well, but it basically turned the Alaskan Indians into sort of municipalities. And therefore, tremendous amount of, what shall I say, graft went on. And that's not only between Indian and Indian, there was some of that, but Alaska became sort of the product of, or what shall I say, sucked into the corporation. And that's a really big issue in Australia now with the big iron ore situation. So it did, the treaties recognized they had title to land. But that's a kind of, what shall I say, they had title to land, but they could be moved to reservations identified not by the indigenous peoples, but by the U.S. government. A reservation in the United States, or a reservation in Canada, is owned by and titled by the Indians. And that's true in the U.S. The Wind River Reservation, not far from me, the fourth largest or fifth richest in the United States, is a huge log of land, which of course you went through recently. Now that's not true, and we may be getting off course here. Oklahoma has more Indians than any other state, but no reservations. The reason for that is they once had reservations, but when the big oil boom came way back in the turn of the century, etc., they dissolved the reservations and made those lands trust lands, i.e. trust lands under the United States government, at which at some point, and it has happened, and it happened in great deal, that the trust lands could be sold to Indians. And the problem with that is while the trust lands were sold to Indians as private lands, even though there was a principle of trust over them to supervise them, many of those lands are sold off because the first thing that happened, every Chicago lawyer went down there and bought them or squeezed them out of them, because who knew what oil was, and secondly, what was the price of the land. That's been heavily reversed now because the U.S. government moved in after World War II and began to reinforce the trusteeship that they had over the Indians. And some of the people, like the Muskogees, are buying their land back, or basically the government is giving money to buy the land back, but it's not complete. In other words, what I'm saying is that reservations were created for, among them, not only original people, but all the Creeks and everybody moving from Georgia and every place else out there. But then, when the oil industry became Indians that need oil, and they don't know anything about it, we will destroy the reservations or alienate the land, and we will have a trust relationship. Those are called trust lands. So there are no reservations in Oklahoma.
I know we only have just a couple of minutes left. I was actually wondering if a reservation system is used anywhere in Russia or Eastern Europe, or treaties have been used as ways of negotiating with indigenous groups here. Is this distinctly a feature of, the British legacy and the Spanish legacy, or do you have reservations and treaties?
We don't have reservations. We have the European Council of Europe Convention.
I want you to look at it as an international, what shall I say, position relative to indigenous people. And my experience, and I'm sorry that I don't have the knowledge and experience outside of the Western Hemisphere, even though I have done a great deal of work for the Maoris, but not in New Zealand, although I've been there a great deal, but also in the nature of the United Nations political and legal construct for the recognition of them. So thanks very much for your contribution. And we will talk tomorrow on the International Declaration, because that is sort of the pivot that I'm driving toward, that is international and has had 143 minus 11, and now the 4 have joined. And that in my view, not because I was involved in the early movements and saw everything come through the system up to the General Assembly, but rather because I think it is now one of the clearest, even though argumentative about it, one of the clearest statements about the global notion relating to indigenous peoples. And that's the first we've had in the history. But it's unique in the sense, and I want to drive that, it's unique in the sense that it recognizes an ethnic class of persons which has not ever been recognized and not yet recognized by the UN. Thank you.